A very good afternoon to one and all. I welcome you all to this session of IIC IIMT College of Law. This session is a part of series of activities conducted by IIC of IIMT College of Law. Institute Innovation Council of IIMT College of Law has been striving towards generating a spirit of enterprise and innovation among its students. And today we have with us our esteemed speaker, Dr. Sanjay Pachauri sir, who is currently working as Professor and Dean R&D, IIMT College of Engineering, Greater Noida. He possesses more than 22 years of experience in research and academics in India. He had also served professor and dean with the Department of Computer Science and Engineering at IMS Unison University and Excel Institute of Management and Technology for 3 years each and BLS Institute of Technology for 6 years. He was member of Academic Council, Faculty Council and Board of Studies of IMS Unison University, Dehradun. He also served as editor for Pragyan, Journal of Information Technology, December 2013 issue, as well as member of Editorial Board, International Advisory Board, reviewer for several international journals from Ohio, USA, Houston, USA, Australia, Ethiopia, Saudi Arabia, Taiwan, etc. He has long-standing academic interest in data communication and networking, network security, and cloud computing as well. He is also guiding 6 scholars for PhD work, and 6 PhD degree has been awarded to his scholars. One thesis submitted for award of degree recently, international patent filed R02. He has also evaluated a number of PhD theses for several universities like Bodh Gaya, Bihar, a central university, JNU Jodhpur, conducted Viva for award of degree. He is also member of PhD Viva expert panel in Department of Science for Magad University, Bodh Gaya, Bihar. In this capacity, he has attended, presented, published more than 35 presentations and papers in different national as well as international seminars, conferences. Few of them are with good impact factor. He also chaired so many technical sessions in different seminars and conferences. I welcome you, sir. Over to you, sir, now.
Thank you, Tanushree ma'am, for a nice introduction. Before we start, what actually the patents and copyrights, what actually the IPR? I would like to share my slides first. Because as per IPR and the patents, this is not a very new concept, not in India. If we are taking this as on the international platform, this is actually the scenario started somewhere around 13th century. Is it now the screen is shared or not? So when we are learning about patents, it's important to understand exactly what patents are and what actually they measure whenever we are talking about the IPR and the patents and the copyrights, all of these things. The existence of this first systematic use of patent can be tracked back around 15th century in Venice. The Venetian patent standard statutes granted patent for any new and ingenious device which was not previously made. It means they were focusing about the new inventions even at that time, which was not previously made. However, in the 17th century, British patent system that is considered to be the first modern patent system, which we are following right now even. Prior to that, patent was awarded by English monarchs to favor in the form of privileges and the monopolies over the trade and premium prices to create premium prices for the certain things or the certain goods. So here one thing which is to be noted, that every foundation of the patent system consists of words like favoritism, privileges, monopolies, trades and goods. This These are the words which are in trade in this system by 15th century till date. These monopolies over the trade lies at the heart of conducting a profitable business. Then and now, if what is the difference in this patent system? The innovation is there in current system which was not in the previous system. So innovation come later when there was a need to identify a fair way of avoiding such trade monopolies. Then just being friends or family of the monarchy system. It means if we are looking into the system in our previous version of the patent filing system, innovation word was not there, so it might be the chance, and this patent was awarded by the monarchy system. So if I am the family member of the monarchy, or if I am a very close friend of the monarchy system, then I might be benefited. So to break out this trade, this innovation introduced this patent system so that the fair dealing should be there. So the patents thus measure to the potential of an innovator to conduct a profitable business via trade monopolies. So when each and every time this particular word monopolies are there, and the we are very well known that the monopolies in the business are not good, then why we are taking these type of words in our patent system? So what they are? So look into the rationale behind this patent system. Why these monopolies should be there? So patents are the award given to inventors by the state. The reward, state means the government. Here the state means the government of the country or government of that particular area. This reward takes the form of a temporary monopoly. It means the monopoly is not the permanent over the business. This monopoly is a temporary monopoly which is having a protection term of usually 20 years. It means you are having the monopoly over your business if you are having a patent for 20 years only. During this time, no one but only the inventor can make it means you can produce your thing, use, sell, offer, either import or export goods protected by a patent. At least not without the inventor's permission, nobody can use it out for this 20 years time span. So why we are rewarding the inventors this type of temporary monopoly for the 20 years? The temporary monopoly is an incentive to carry out research that requires not just ingenuity and hard work, but also substantial investment. Research and innovation is also a risky business. It can take tens of years before an inventor, hard work and investments bear fruits. In such cases, patents represents the light at the end of the tunnel where the researchers can reap the benefit of a temporary monopoly. So a classic example, if we are taking an example for this, why this temporary monopoly should be there, just consider an example. A classic example of this phenomenon can be found in the pharmaceutical industry. Research into new drug development can incur billions of dollars of investment. Thereafter, new drug have to undergo many years of testing and regulatory approval procedure. It can be argued that without the trade monopoly over their novel drug, the big pharmaceutical companies would have no incentive to carry out long and expensive research. So many drugs, we know them today, would not on the shelves of the medicine shop without the incentive provided by the patent system. And a very recent example of this particular drug is the vaccine of this COVID-19. This is the fastest developed medicine by the pharmaceutical industry around the globe, if this particular vaccine got patented, then the cost of this vaccine was so high, so nobody, that was not very easily to be available, easily available to all of the persons in a particular country. So what we made, entire globe passes a resolution that no one will make a patent over this particular vaccine. That's why we are getting this vaccine in a very cheaper price, otherwise it might be few thousands of rupees. So if we are going to a disclosure, now we know what actually the innovation is and what actually the temporary monopoly is, the heart of the modern patent system. But there is a third aspect also that we need to talk about. It is very the reason why you and I are here at this moment of discussing about the patent information. The temporary monopoly gives to inventor comes at a price of disclosure. Yes, patent data is public. All patent offices globally are required to publish patent at least 18 months from the date of filing. What I would like to say, suppose you are about to file a patent of any of the date and you are applied for that, it would take minimum approximately 18 months to publish on the patent site. It will take this much of time. Why this much of time is required? This much of time is needed to evaluate your patent, because patent evaluators are also there, patent examiners are also there. They have to evaluate your patent, then only they will finalize it for the publication. So this much time is needed for that. So in this way, anyone from the public can learn and improve upon the innovation. This aspect of patent system fulfills the social aspect of knowledge dissemination. So each and everyone may know what actually the new thing within this particular patent. So what is the importance of valuable patents? As we discussed, that patents are temporary monopolies given to innovators as a reward for their agility and risk. The following graphic shows the patent filing trends in the top 5 patent offices in the world. What are the top 5 offices? We are having the top 5 offices in like China, Korea, European Republic, Japan and USA. So by these 5 colors, we can get it out very clear what actually the trend of filing of the patent. So this red line, red is Democratic People's Republic of Korea. If we are considering it by 1980 till 2018, they are having a very constant patent filing system. They are filing a very constant rate. But before it, this European Republic in 1980, it was approximately the same as per the Korea, but till 2018, it is little bit higher than this. The drastic change we can found it in the graph of China, this blue graph. Till 2006, 2010, 11, these were almost in the same cadre, 50,000 patents cadre. But by 2010 onwards, there is an exponentially changed in the graph. They shooted it out from 50,000 to 1,50,000. 15 lakh, not 1,50,000, that was 15 lakh. So this is the drastic change. There is a 5 international great offices where the patents are filing, and this is a trend which we can see, which we can get very easily. So the steady rise in the patenting shows that inventors really respond on the incentive of temporary monopoly. Over 3 million patents are filed globally every year, approximately. Needless to say, all patents are not the same. There is significant variance in their technical and commercial values. Empirical research has been shown that half of the estimated patents value belongs to only 5% of the entire patent population. This is where the work of a business patent analyst must include to efficiently search relevant patents and differentiate more valuable patents from the less valuable patents. So by going through all of these, there is a very clear symbol to all of us that patent analysts' jobs are also maybe taken as a career, because this much approximately 3 million patents are filing globally per year, and we are consuming approximately 18 months to file a particular patent or to publish a particular patent, because we are not having the sufficient number of patent analysts. That's why this much time is there. If we are having a sufficient number of patent analysts, which can analyze these patent in a short duration of time, then this much time might be reduced. So innovation is known to drive economic growth, making the lives of everyone better, but this benefit to the society comes at the price. If you are going to give benefit to anyone, you have to pay some price. So new patents are of course a benefit to the society, but their benefits are coming on a particular price. Anyone who has studied economical fundamentals would know that monopolies are bad. Of course, this was a word which I have used a little bit earlier. Monopolies are the bad, but creates deadweight losses for the society. Hence, the job of the patent system is to strike a delicate balance between benefit to society and evils of monopoly. This balance is achieved in two ways that we have already discussed, but I will summarize again. So to the point, my step. First, patents are temporary monopolies. It means monopolies are not the permanent monopolies. That's why we are saving our society by evil of the monopoly. Temporary, because a patent provides protection to its owner for the term that is usually 20 years from the date of filing. And this is very, very clear. If by the date of filing, it will take minimum 18 months, approximately 18 months to publish. It means within this 20 years, approximately 2 years has been gone. So we are having the monopoly for the next 18 years only. And if we are going through the analyst and we are going to pass out the examination and all, it may take 4 to 5 years even. So we are having the monopoly for the next 15 years only. So all patents that have lapsed, expired or abandoned come in the public domain as free knowledge that anyone can use. Secondly, the guarantee of exclusive rights comes at the expense of the disclosure. Patents are public knowledge and someone can learn and build upon them, thus making knowledge more global and accessible. In order for the patent system to function in a healthy manner, it is important that the evil of the monopoly do not override the benefit of the society. I think, just let me check it first. Yes, I'm getting right now. I got a message that slides are not moving. So I would like to know Now, Tarun, may you now, is it moving now? Right, thank you. So let us have a look on the patent's life cycle, what actually the patent life cycle is. Now that we understand the importance of the valuable patents, I want to talk about the system that ensures that the modern patent system is categorized by a lengthy and sophisticated examination process. Every patent undergoes a test for novelty, non-obviousness, and industrial applicability. And these three key criteria for a valid patent before being accepted or refused. A granted patent can be challenged by any third party in various forms, adding to the length and complexity of the patenting process. The figure which I am going to show you on the next slide is simplified version of the patenting process in most of the patent offices across the world. So this might be the system. Here we are going to file a patent. Approximately 12 months will be taken by any foreign or the PCT filing. Any minimum 12 months might be required, and till the publication time it might take 18 months. And whenever we are going to appear into the examination, as this is an examination process over there, so we have to, after publication, we have to appear into the examination. Here within this examination, two results might be there. Either we may pass, it means the patent might be granted, or patent might be refused. So by the date of patent filing till the granting of the patent or the refusal of the patent, it might take approximately 5 years. So we are having only 15 years left for our temporary monopoly. If patent is granted, then any third party may go through a position and they may raise an position that this is not either the right or wrong or whatsoever the grievance they are. And if you are having a refusal, then that particular inventor may reappeal. He may go through the appeal in the court, in the patent office. But this is not the refusable type of patent, you have to reconsider it. So you will notice from the previous graphics that patents are not one-shot action. It takes on an average even 5 years to get a patent grant decision. This time is also called as the patent pendency. During this time, innovation does not necessarily come to a stop. Key investment and technology commercialization decisions are taken within this time duration of the 5-year. Product marketing and go-to-market strategies are prepared. Follow-on innovations and investments in complementary assets are made to make the most of the granted patents. So what big companies are doing within this time? Big companies often outsource the management of the patent life cycle to professional law firms. Patent management constitute all activities that enable firms to reach their strategic objectives. It encompasses identifying inventions, filing applications, managing patent office actions, monitoring status, paying renewal fees, negotiating with the contracts, identifying contemporary investment strategies, and much more. All these efforts lead to a self-selection of the most valuable inventions. Since parties will only pursue applications and make further investments on innovations or inventions, what they are getting into the patent office and showing the potential into the market. So while it is necessary to ensure that only truly novel inventions are granted patents. Protection. The long pendency times are also a cost to the innovations ecosystem and hence to the society even. To understand this thing, suppose this COVID vaccination, if this COVID vaccine will fall into the patent system, then if it will take 5 years, suppose 5 years, so we will not get any vaccine into the market till 5 years even. So society has to pay the cost. What was the cost? It might be the entire country might be ruined. Any of the country might be ruined because none of the citizen was protected by this vaccine. So casualties might be more higher and higher side. So that's why it was decided not to go through the patent system. So they have to pay the cost. Even society has to pay the cost. Product life cycles are getting shorter, which means innovators have less time to develop, less time to roll out and exploit their inventions' profitability. If a new technology can replace an older technology in 5 to 10 years, then how can an inventor justify the cost of a 5-year patent pendency and then use a 20-year patent protection term? So these challenges are not new in the last 300, more than 300 to 400 years history. If we are considering it by 17th century, this is approximately 500 years. And if we are considering it by 15th century, then it is approximately 7 years. But we are considering it on the 300 years scale because the new patent system was approximately 300 years old. So 300 years old history of the patent system. Patent offices constantly come up with measures to ensure faster pendency time, hiring more examiners to clear backlogs, faster first office action to ensure self-selection of the serious inventions, putting processes to weed out weak patents. To name a few, if we want to name a few, innovators also find new ways to use patent protections. What are the new ways actually? So what are the motivation to file a patent? As students and the faculties should file their idea as a patent, they should file their self-prepared notes as a copyright. So as we have discussed so far, the traditional motive to file patent to obtain exclusive right over an innovation. So the patent holder can then enjoy the benefit of the temporary monopoly to run a profitable business. The method of appropriation involves either making and selling the inventions exclusively or extracting licensing and royalty income from others who are allowed to use this invention. We also saw now in the first 4 decades, there has been a huge rise in patenting. This increase in patenting has been linked to many modern motives to file patent. For example, patents are often filed for a blocking rival from patenting in related technologies, protecting against infringement suit, and using patent in negotiations over technology rights. Here I have compiled a list of various motives to file a patent along with some context. As very first is blocking competitors from entering into the technological domain. If you are having a particular technology and you are the very first into the market, and if you are not getting the patent, then it might possible that so many competitors might be there into the market with a similar technology by going through the reverse engineering. So it is always beneficial to everyone that go through the patent first. So if you are having the patent, then it means you are indirectly blocking all of the competitors because they can't compete into the market by using that particular technology because that is copyrighted. So the legal action might be taken against all of them. So blocking competitor or any other third party is a common motive to file a patent. The patent holder may or may not use the invention that they wish to obtain a patent for. If you haven't already, I urge you to read this interview on patent records that talk about the phenomena and strategies deployed by various industries. The second thing is increasing bargaining power. If you are having the patent, you are having the more bargaining power with you. During merger and acquisition of the company, suppose you have run your company for 3, 5, 7 years with the same patent and now you would like to sell it out and patent is in your name, you may bargain with the purchaser that you are having the patent and you are also selling your patent along with the company, then you are having a great bargaining power in. So firms holding large patent portfolios have bargaining power that can materialize as liquid assets. Then third point is securing freedom to operate. Freedom to operate, this FTO, is a term used in patent prosecution terminology that gives any producer the right to make or sell products in the certain market without infringing upon patents held by third parties. It is a repository of manufacturers who are planning to introduce their products in any market to carry out a freedom to operate analysis. In industries such as information and communication technologies, that is ICT, patents have vague boundaries. Products are usually made by compiling various technologies and players can be less known. So it is particularly challenging for a firm to carry out a flawless freedom to operate FTO before introducing into the product in such industries. Then gain time for evaluation. We are having the very gain time. For most innovations, there is uncertainty about where the actual market might exist. The inventors themselves face uncertainty due to investment or time pressures. The delays examination process give time for applicant to figure out these uncertainties before deciding to proceed with the patent application. As we are very well known now that publication takes 18 months and till granting of the patent it took approximately 5 years. So this 3.5 years are very much sufficient for the innovator of that particular technology to make themselves prepare according to the market and all of these challenges. These includes looking for potential licenses and investors. Earlier in the course of time, it is shown that patent life cycle that can be even last up to the decade. So it may enhance your reputation even. Since patents are one of the most patents, there is a technical issue again, I think so. So I have to share it again right now. Is it visible and is it moving now? So in the course of enhanced repetition, if we are having the oh sorry, since patents are one of the most tangible measure of the innovation, many economists and analysts use them as innovation indicator for lack of other alternatives. Firms are also judged by their investors based on the amount of intellectual property what they create actually. In some top pharmaceutical companies, a poor patenting report might shut down the entire unit. Many firms thus have guidelines as to how many patents application they may be targeting in that particular year. So they have to focus on the new inventions each and every time, and they are having the target to file the patent year wise. So we are having a forum against the infringement suit. Striking intellectual property is a common practice among top ICT firms, where the threat of countersuiting is enough to prevent many patent-related lawsuits. So we are having a very good interview and very good material available over the LinkedIn. You may read that thing out to get out these how these suits are going on into the market. We are having the secure priorities. This motive might be important for applicants looking to target geographically disappears market according to the pair convention. Patent applications have 1 year after making a priority applications to extend their application to other countries. So if you have filed a patent in our country, after 1 year you may file another patent into another country. This time period can be extended up to 30 months by filing patent under the Patent Cooperation Treaty, that is PCT. Under the Patent Cooperation Treaty, you may file the patent after 1 year, it means after 12 months till 30 months into any other country even. This motive is related, gaining time for evaluation and motive to defensive publications. Why we are taking this thing to file a patent into the another country, even as we have filed the patent in our country and we are making the profit in our country. Now I am having the sufficient amount of money and I would like to spread my business in another second country. I may file the patent over there within this 30-month duration time when the patent will be granted to me. Till this particular time frame, I may plan all of these background issues and I may start my business just after taking the patent. Thanks a lot to all listeners. If anyone is having any query, you are most welcome.
The session is open for questions. In case anyone has any questions, you may. So, in case of any questions, we will be sending you to your personal WhatsApp person. As we come to the end,
also send it to me on my official mail ID so that I can answer all of the questions accordingly.
as we come to the end of this session, I thank you so much, sir. It was indeed a privilege and honor to have you with us today as a speaker. All our participants must have learned a lot today. Thank you so much, sir, once again.
Thank you, Tanushree.